afternoon. My name is Idamara Rodriguez, and today I'll be presenting Graywork 3.4 based on an Android Note app. For purposes regarding this Graywork assignment, I intend to exhibit debatable presentation and use of computer code. In this instance, I have conceptualized the creation of a new note-taking app for Android systems. My Notes app is inspired and built on previous note-taking functionality and modeled for Android systems. Aesthetic changes and added functionalities were embedded into the program. The source code for the Notes app contains information obtained from various open code sources, registered work of co-creators, as well as material created by me. This work is intended to be disseminated through the internet by making the program freely available for download. Revenue is expected in correlation to advertising snippets within the app. Initial budget for this project was approximately $10,000. Marked green, you can see an example of what the source code could look like. The legal ambiguity of my proposal rests on the amount of public source code utilized as well as gray areas regarding trade secrets, previously copyrighted material, and various issues you could encounter factoring the interoperability of electronic devices. Chapter 700, Section 721.8 of the Compendium of U.S. Copyright Office Practices states, "A derivative computer program may be registered if it contains new material that is sufficiently different from the pre-existing work, such that the program qualifies as an original work of authorship. The new material must be original, and it must contain a sufficient amount of copyrightable authorship. Nonetheless, as in the case of the creator of Linux, the exact amount of necessary copyrightable authorship for transformative computer programs is not resolute. Neither is the amount of license code provided to me by third parties, which is privately agreed upon, or open source code providers relying on fair use by both parties." Chapter 1500, Section 1509.1 of the Compendium of U.S. Copyright Office Practices. A registration for a derivative computer program covers the new or revised material that the author contributed to that work. It does not cover any previously published or previously registered or public domain material that may appear in the program, or any authorship fully or partially owned by a third party. In view of this, I expect there to be enough questionable details to argue whether my work is clearly illegal or not. Herein the gray area of my submitted work. I had licensed open source work as my own. The integrity of the original open source code was compromised. The code for the program is being kept private and obscured to the public. An additional license was requested. The source code was input for the making of a commercial product. The product made, described as a note-taking application, is a closed digital environment which cannot be edited or reproduced. The source code utilized lost its neutrality when I edited into the program with private specific interface. Here are some of the references I used for my work, where I obtained code and the practices for open source and guidelines. Thank you for your attention.